Legislative Day number 27 will now come to order. Let's please pause for a moment of silent meditation, and perhaps Councilman Marks, this may be a good time to make your mention before we go into meditation. Would you like
Sure. Thank you, Madam Chair. I regret to inform the council and everyone watching that Eugene Kibbe passed away. He was a former Republican councilman who was a longtime owner of a Towson insurance agency. He represented the 4th district, which then included Towson, from 1974 to 1978. He was active in Army intelligence. He was an avid voter and very active in the Southland Hills community, so regret to hear of his passing.
Well, let's have our silent meditation for the former councilman.
Madam Chair, can I also mention, and I'm sorry to interrupt, but
sure.
We also lost last week Sandy Williams. Sandy Williams was a judge in the district court for about 20 years, and she was an assistant state's attorney in the 80s and 90s, and then ascended to district court cancer. And she passed away of cancer last week. She was 64 years old.
Well, thank you for sharing that with us as well. And I guess I'll take this opportunity as well, instead of doing it at another time. Regret it's with deepest sympathy, and it's just so unbelievable. But for those of you that knew Mike Baker, who worked for Congressman Dutch Ruppesberger, Mike was with him for decades. He was his East Side constituent services person, and was the one that was very active in the Democratic clubs and all the communities. And we're not sure if they found out, I don't know yet, but he didn't show up and didn't answer his phone, and they went to his residence and found him. Mike was not married and didn't have children. He devoted his whole life to public service and to Dutch Ruppesberger. And he was a good friend. Thank you. Thank you. David, since you're in your office and you have a flag, would you like to lead us in the Pledge of Allegiance? Anytime you're ready. You're muted, David.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Yep.
Is there a motion to approve the journal for the meeting of November the 2nd, 2020?
Second.
Okay. All in favor?
Aye.
Aye.
The journal is approved. I'm sorry, I can't see. My glasses are stained up. Give me one sec here. We'll continue on with the enrollment of bills. Bills 101-20, 102-20, and 104-20 were passed by the council, signed by the county executive, and hereby enrolled. Mr. Secretary, will you now read all bills for introduction?
Thank you, Madam Chair. First for introduction this evening is Bill 118-20, Current Expense Budget, Department of Commerce Restaurant Relief Grant Emergency Measure. Bill 119-20 is also Current Expense Budget, MEMA Hazard Mitigation Grant Plan. Bill 120-20, Current Expense Budget, DHCD CDBG CV Fund. Bill 121-20, Current Expense Budget, Lead Paint Hazard Reduction Grant. Bill 122-20, Current Expense Budget, buprenorphine Project. Bill 123-20, Current Expense Budget, COVID-19 CDBG and Eviction Prevention. Bill 124-20, Current Expense Budget Baltimore County Crisis Services Awareness Campaign Project. Bill 125-20, Current Expense Budget Baltimore County Detention Center buprenorphine Project. And finally, Bill 126-20 is sponsored by Councilman Marks, Zoning Regulations, Honeygo Area, Panhandle Lots.
Thank you, Mr. Secretary. The council will now consider all bills for final reading and vote. Mr. Secretary, first bill, please.
Bill 97-20, Permits, Approvals, and Inspections, Event Permits.
Thank you. And we have Mr. Michael Malinoff to testify this evening. There he is.
Hello, Madam Chair. I'm
Good evening.
sorry for your loss.
Thank you.
2020's been a tough year for many of us, hasn't it?
For sure. Thank you.
Council, as a reminder, the bill is titled Events Permits. The purpose of reorganizing certain provisions related to the event regulations, permits, and amusements, recodifying certain provisions on explicit movies shown in open-air theaters, clarifying certain department roles, and reviewing event permits, creating a certain category of permits for carnivals, establishing requirements for certain event permits, requiring certain responsibilities of event permit holders, establishing grounds for certain event permit issuance or denial, establishing certain restrictions on the issuance of event permits, and permitting the county to inspect certain permitted events and revoke certain event permits and generally related to event permits.
And I understand we also have an amendment.
There are several amendments, Madam Chair. If you'd like, I can go through them.
Would you please?
Yes, ma'am. The first set of amendments is submitted at the request of the administration, the county executive. The first amendment on page 4 of the bill pertaining to the detail pay policy, it adds, it specifies that the pay policy is under section 21-9-103 of this subtitle that it refers to. It also, where the pay policy mentions that an applicant may be required to pay for services provided by on-duty officers under certain circumstances, this amendment would remove the under certain circumstances phrase. Additionally, in the body of the bill on page 5, in the definitions section, the amendment would add a definition of carnival, and carnival is a defined term in the business regulations article of the annotated code of Maryland, and this amendment would essentially borrow from that definition to create the definition in this bill and in this section of the county code. And then finally, the amendment would, at the very end of the bill, instead of the normal 45-day effective date after enactment, it would extend it to 60 days. And I believe the administration's rationale is to have more time for outreach.
Thank you. And that's the First Amendment?
Yeah, yes, ma'am. That is the first set of, there's, I think, 2 more from several council members, but this is the amendment submitted by the administration.
Madam Chair,
So we'll vote on the amendment, each amendment separately.
Madam Chair,
Excuse me, wait a minute. I'm asking Mr. Boswick. So will we vote on each one separately since one's admin and 2 are council members?
Yes, but the only one before you at the moment is the ones that I just listed, which are the administration amendments.
Okay. I'm sorry, Councilman Catch. Go ahead.
oh, that's all right. Just to make this clear, so this amendment will apply the reimbursing the county for additional police only for these carnivals, nothing else, correct?
Carnivals and circuses.
And circuses. So they'd be the only 2 events
Correct.
where the promoters would be paying the money, the extra money for the extra police support. Okay.
Well, if the police chief determines that.
Right.
Madam Madam Chair.
Yes, Councilman Crandall?
Sure. I don't know if Councilman Catch may have jumped the gun on the detail pay issue within this bill, but I just want to clarify that when you look at the state's definition of carnival, it really means any event open to the public that has mechanized rides or forms of entertainment that you think about a carnival has, a Ferris wheel, tilt-a-whirl, merry-go-round. Now that is, so a lot of events, certainly in my district and throughout Baltimore County, would be considered carnivals. So this isn't just carnivals at malls that have no nonprofit sponsor. These are carnivals put on by rec councils, chambers of commerce, volunteer fire companies, private schools, etc. So I just wanted that to be clear, and I think all the attorneys in the room would agree with that assessment.
And Madam Chair, yeah, and that is, it's that way on the state level because the state is responsible for making sure all the rides, et cetera, are safe. So that's why the definition is the way it is.
Okay. Does anybody have a motion to move the First Amendment?
I'll move it.
Well, Madam Chair, before you ask for a second,
Sure.
so I'm not necessarily opposed to this amendment. I think it cleans up the bill a little bit. However, I had taken issue in several of our meetings on this legislation with the line that gives the police chief authority to charge detail pay under certain circumstances. So I expressed my concern about the lack of detail within the words under certain circumstances, and I wanted greater definition of that. So the administration's request wasn't to define the certain circumstances, it was just to strike the terminology of under certain circumstances altogether, which in my opinion, really, I mean, it doesn't do anything to the bill or address the concern about when this policy would kick in. So I think that aspect of aspect of this set of amendments is kind of a nothing burger. So I'll just leave it at that. But
Mr. Benjamin, do you want to comment on that or not? Were you saying, Randall, that you were waiting for the administration to get back to you and they didn't on that specific?
No, absolutely not. The administration has been very cooperative and willing to work with both with me and various community event organizers. And no, I'm certainly not saying that.
Oh,
No, what I'm saying, I was disappointed with the amendment because it didn't address my concerns of the language.
What I would suggest, Madam Chair, is there were a couple of concerns that I had with regard to some of the language in Councilman Crandall's amendment. So if I may, I would like to reserve comment until you and the members discuss his amendment.
okay. Are there any comments or questions on this amendment?
Madam Chair,
Yes.
Michael Malinoff, I just wanted to mention that where we left it with the council member is that when we develop our policy that we would share and work with the community on that. So that's why the language was created as it was, because we felt it would be important to set it up and share it with the community so that they would have input and they would understand where we were coming from.
Okay.
We felt that this would be sufficient without hamstringing the police departments.
And Matt, oh, I'm sorry. And Madam Chair, I have the same recollection of our conversations that Mr. Malinoff has. And if he recalls my statement to that as well, we'll pass the bill and then we'll work on the policy. I had a let's pass it and then we'll see what's in it moment. And I said that in our last meeting, I believe. So that's kind of where we are.
Okay. All right. Anyone else? Okay, then let's, is there a motion
You have a motion.
and a second? Is there a second amendment?
Jones, second.
I'll second. Okay, second in Tom? Okay, all right, there's a second. Okay, Mr. Secretary, please call the.
Madam Chair,
Yes,
Councilman Quirk was the one who motioned. You need someone else to second.
oh, I'll second. I'm sorry, I thought, wait, I'm sorry, I thought Todd did. Okay, we square now?
Just,
Yes.
Madam Chair, I'm sorry, I'm having some audio difficulty where it's coming in and out. Am I the only one?
I am too a little.
Stay,
I just want to comment that
I am as well.
I'm not trying to point fingers, but it's Councilman Catch. I just muted him and now you know it's gone.
no big surprise there.
I know. I don't want to mute him permanently because he has to vote. But I just muted him and the background noise has disappeared. So I'm not sure what's going on. But
He's rolling his eyes.
It's a TV.
I'm sorry.
It's a television.
Okay, so, okay, there's a first, a second. Mr. Secretary, please call the roll on the First Amendment to Bill 97-20.
Thank you. Yes, ma'am. Mrs. Bevins,
Aye.
Mr. Quirk,
Aye.
Mr. Patoka,
Aye.
Mr. Marks,
Aye.
Mr. Jones,
Aye.
Mr. Crandall,
Aye.
Mr. Catch.
Aye.
The First Amendment to Bill 97-20 passes. Mr. Secretary, next amendment.
Thank you, Madam Chair. The next amendment is sponsored by Councilman Quirk, and this also deals with the detail pay policy. The amendment would, after it's in, let me get to page 7 of the bill. Page 7 of the bill states that except as otherwise provided in this subtitle, a person shall receive a parade permit issued by the director before the person may engage in, participate in, aid, form, or start a parade. This amendment just adds an additional sentence to say that a detail pay policy adopted in accordance with this title shall not apply to parade permits issued under this section. So it essentially specifies that parade permits are exempted from the detail pay policy requirements.
Okay, any questions or comments about the Second Amendment?
I'll move it.
Is there a second?
Second.
Okay. Mr. Secretary, please call the roll on the Second Amendment to Bill 97-20.
Mrs. Bevins,
Aye.
Mr. Quirk,
Aye.
Mr. Catch,
Aye.
Mr. Jones,
Aye.
Mr. Crandall,
Aye.
Mr. Patoka,
Aye.
Mr. Marks.
Aye.
Okay, the Second Amendment to Bill 97-20 has passed. Mr. Secretary, Third Amendment.
Yes, ma'am. The Third Amendment is sponsored by Councilman Crandall. This also deals with, not surprisingly, the detail pay policy aspects of the bill. And this states the detail pay policy is on page 4, as we've discussed in the other amendments, and it states that the chief may adopt a detail pay policy under which applicants for a permit may be required to pay for services of on-duty officers. It also states that the policy may require prepayment or security, and that the administrative officer shall establish and from time to time review the fees. Mr. Crandall's amendment would add another subsection to this section of the bill, and would state that, would specify that the section that we're talking about regarding detail pay policies does not apply to an applicant for a permit under the subtitle that meets the following requirements. And there are 3 requirements that they would have to meet. 1, that the applicant is a nonprofit organization with its principal location in the county. 2, that the applicant has sponsored a carnival in the county at the same location and scale for at least 10 consecutive years, excluding force majeure related cancellations. And 3, that the applicant has successfully coordinated the security for such a carnival with the police department in each of those years. So if you do all 3 of those things, the detail pay policy would not apply. And then there is a second part to the amendment that states that an applicant that qualifies under the exemption that I just read, that has in the previous year provided inadequate security such that an emergency call for service was made regarding crowd control, assaults, property damage, or other disruptive behavior may, at the discretion of the chief of police, be subject to the detail pay policy requirements of this section. So again, to recap it, there are 3 circumstances where an applicant would not have to utilize or would be exempt from the detail pay policy. But even if you were exempt, if you had a situation of emergency calls that I just read, then you may be subject at the chief's discretion.
Madam Chair.
Yes.
Yeah, if this amendment were to pass, under what circumstances then would detail pay apply?
I think from what I gleaned,
Wade, you gotta mute.
all other situations where the applicant is not it would only apply to these under these 3 circumstances. So if you didn't meet those 3, it would apply.
So, Mr. Katz, did that answer your question? Yeah. So
I think so. Council, if I may, Madam Chair, Councilman Katz, if I'm not sure if I understood the spirit of your question. So there's a couple things going on here. This amendment would exempt longstanding community events that by definition are carnivals from the detail pay policy, right? So so that I think that hopefully clarifies the amendment. Now, in the way that the bill is written, amended or not amended, with this 3rd amendment, the responsibility or the authority to charge an event or the permit applicant, sorry, that is at the discretion of the chief of police. And again, there are no criteria that we're aware of where these decisions that are going to guide these decisions. Now, Mr. Malinoff stated that they'll work on the policy after the bill passes, and I'm not especially comfortable with that. But the detail pay would be at the discretion of the chief of police, as I understand the bill. And someone can correct me if I'm wrong about that.
Mr. Benjamin, could you comment on this amendment, please?
Sure. Thank you, Madam Chair. There are a few concerns that I have. One is the language that is in the amendment concerning the applicant has sponsored a carnival in the county at the same location and scale for at least the past 10 consecutive years through the current year. It seems that the 10-year clause that's akin to a grandfather clause and a rolling clause such as that would be impossible to track and very difficult to enforce. I'm concerned that there may be questions with regard to how it would be interpreted when you talk about I guess in section 2, where it says the applicant has sponsored a carnival in the county at the same location and scale again, for at least the past 10 consecutive years. When we talk about, when it talks about and scale, does that mean a number of rides, the number of people who happen to attend in a given year? I'm concerned that it would be impossible to apply without an uneven application. And then also too, as any large event, is likely to be a 911 call, and it may not have anything to do with faulty management of the event. So I'm concerned about a fairness application there as well. And then when you talk about the subjective nature of the provision at the discretion of the chief of police, that could result in disputes as to whether or not the chief is abusing that discretion. And so you're talking about a subjective determination, which could be problematic as well. So those are some of the concerns that I had in reviewing the amendment.
Okay, Madam Chair, can I respond to a couple things?
Sure.
Thank you. Thank you, Mr. Benjamin. I'm not quite understanding why this would be impossible to track. If an event occurs on an annual basis, we certainly have a record of their permit that was granted for at least 10 years. So I'm not quite sure why we can't track it. So I need to ask about that. You know, and I look at your concerns within the bill of. I think that the amendment still provides a lot of authority and discretion of the chief of police, because although it does not go so far as to define the number of calls and what misdemeanors or felonies may have been committed, it doesn't go that far. So I say, let's pass the bill and see what's in it. Pass this amendment, and we'll see what's in it. If it works for one way, it should work for another.
Well, I think that my concern with regard to, well, there are a couple of things. One, I think that there would be adding additional administrative burdens, and I think that's what I was talking about with regard to looking at a rolling grandfather clause. And then also too, with regard to basically we're talking about, I guess it's a commerce clause issue. It would seem to me that there's an uneven, I guess, burdening of commerce with regard to some carnival companies and not others. Also too, with regard to nonprofit organization with the principal location in the county, that language is concerning to me too, because a lot of nonprofits may not have a particular location. In fact, some community groups, have PO boxes or a home address of a board member. So that also could be, that concerns me as well. So I guess when it comes down to is just, I'm concerned about the administrative burden. I'm concerned about whether or not this would infringe upon commerce clause, and being able to apply this fairly and have equal standards.
Well, I would, so things are grandfathered all the time, Mr. Benjamin. So I don't see where, I just don't see your concern on that. As I said, things are grandfathered all the time. And, I received correspondence from the administration today that the grandfathering would be unfair. Well, it's my contention that it's unfair that we're lumping in these community groups who do nothing but provide part of the fabric of our communities, are lumped in with these bad operators, and now may face some things that they currently don't face. So it's, I think by trying to solve this problem, which I fully appreciate, and I appreciate all the effort that has gone into this, but in trying to solve a problem, we may be creating problems for other people that don't deserve it. So that's kind of where I'm coming from. So the legality of it, That's what I'm concerned about. The constitutionality of it, I get it. I think that's what is always looked at when we ask our draftsmen, the council's counsel, to weigh in on as we come to them with ideas. And in discussing this with our attorneys, I don't want to speak for them. I'll let them speak, but I did not feel they would have advised me not to move forward with the amendment if they felt that it was unconstitutional or in violation of some federal law regarding commerce. So I don't know if I wanted to cause a debate between attorneys tonight, but that's so we did assess that when we put together the amendment.
Madam Chair,
Yes.
I'm an attorney, but I'm not going to address the constitutionality right now. It's more the regulatory aspect of it. And many of these items, and I certainly respect the council members' drafting of this, are the regulatory items that we were talking about that staff would get together and put together with the police department and all the other agencies and present to the community and to the county executive. And it becomes a little difficult. For example, on the rolling 10-year, what happens if an event moves a location? What happens if an event changes management and leadership? And then does that become a completely new event? And then we're in the position of having to justify it or not, whether or not it's been for 10 years. And that does happen in events. And in drafting our amendments, we really went to the heart of it and eliminated all but carnivals and circuses and added the language of what a carnival means so that there wouldn't be ambiguity and we wouldn't be necessarily focusing in on an event that had an ancillary use of a carnival that the community's been having for years. So from a regulator's standpoint, I think this language does create some problems and is really what we wanted to create in the actual enforcing of the legislation.
And if I may add, Madam Chair, to address Councilman Crandall's issue or question or point, I should say, regarding grandfathering, you typically grandfather those entities that are already in existence. And I think that as I read this would grandfather in new entities. And so then that's why you have or would have difficulty as far as tracking and continuity. And that could also lead to inconsistent application, which could open the door to potential discrimination claims down the line. So as counsel to the county council, which I am also, it's important for me to be able to share my concerns with the members, and that's what I'm trying to do this evening. Thank you.
Madam Chair. I guess I had a couple of questions that anyone can answer. Number one, why we do not have a policy now that we can see in terms of who's going to be charged. And number two, is it correct that before a person is charged, that'll be part of their security plan? And I'm assuming that we wouldn't accept their security plan, and then we would tell them before the event ever starts, before a permit is ever issued, that they have to hire additional security, or does some event occur and we call and 911 is called and 1,000 police show up and the person gets a bill in the morning? Can somebody explain to me how this works? But I'm assuming the policy is not written yet. So
Correct. Madam Chair, may I?
Yeah, sure.
Councilman, yes, the policy has not been written yet because of the timing of the sequence of adopting the legislation. As you very well know, coming from Anne Arundel County and Annapolis, the many events that we had, this is something I'm very familiar with. And the way that this is being drafted is the event coordinator will submit what they're doing. The police chief will review it. There is a security plan that they would submit. It may very well be that for whatever reason, the police chief does not feel that that's sufficient for the needs of the event. And at that time, the police chief would provide the detail pay based on the policy that's developed. The after effect billing is not something that's in the bill. What it would affect is the next time these people would apply, whether it would be the operator or the event organizer. So that's kind of the layout of it. And if you have any more questions, I'd be glad to answer.
Can you repeat that part for me again about when they will have to pay?
That would be if you had the circus or the carnival and they submitted their proposal for their event, and the police chief, and the regulations haven't been developed setting up all the pay and what that would be. We had conversations with Councilman Crandall about it, and generally, as you're familiar with, it would be based on what the current pay scale would be. It wouldn't be anything much different. And the police chief would review it, and they would say, I don't think the security plan is sufficient to provide the level of protection we need. And perhaps like the one that happened at East Point Mall, and they wanted to set up in Security Mall a few months later, and the police department would come back and say, we're going to have to provide X amount of officers at X amount of time at X amount of pay, and this is how much it would cost. It wouldn't be after the effect. In fact, right now, the county code allows for the fire department to bill if there was a violation, a safety violation noted, it wasn't addressed, and there was a fire afterwards. And I don't think it's ever been applied. But we made that known during our discussion as well. So it really is not going to be an after the fact punitive bill. What will happen if there is an after the event or during the event issue and we hadn't billed is the next time they come in and apply as an operator or as a sponsor, that would prove to be problematic for the event sponsor or provider, and that's in the legislation as well.
Madam Chair, if I may, I'd like to weigh in. As the council's legislative counsel and secretary, I would only say that to me, this is a policy issue. And if you agree with Mr. Crandall's policy of wanting to exempt an applicant that meets those three criteria that I read from the detail pay policy, then you should vote for this amendment. If you don't necessarily agree with that policy decision, then you shouldn't vote for this amendment. I don't think there's any, I've been doing this for quite, and I would have no compunction saying that there's nothing unconstitutional or illegal in this amendment. And I respect Mr. Benjamin's concerns, but we've reviewed those as well. Thank you.
Madam Chair, if I could, listen, I know a lot of work went into this. I understand that Councilman Crandall certainly has been much deeper into it than a lot of us. And I mean, I appreciate the reason we're doing all these things. But you say we don't have a policy written because we're in a hurry to get this legislation passed in the middle of a pandemic when we don't even want 10 people and we suspending all kind of activities. I'm just thinking to myself, like, is it really necessary that we rush to get this thing done when in fact nobody's meeting anywhere? And basically what this amounts to, and I don't mind voting tonight, I don't have a problem, but what this amounts to is we're giving sort of a blank check to say, make any policy you want. And someone brought up an issue the other day where there was some event and there was dump trucks parked at the end of the street. And listen, this is the world we live in. I understand it, but people may not understand if I give this carnival for the last 20 years and now all of a sudden I got to provide security for Al-Qaeda and I have to worry about car bombs and trucks. And I mean, it can get extremely expensive. And I guess my point is, if we're going to pay for any police officers, I would hope that that would only be additional police officers and not the ones that are on duty at that particular time who is there for any type of emergency. And is any of this negotiable in terms of with the applicant?
Madam Chair, can I answer?
Yes. Mhm.
Yes, it would be an addition. The way that a detail pay works is you'll have public safety officers on duty anyway. And we have actually had events during the pandemic. We had some requests for concerts over at the Timonium Fairgrounds. And part of the discussion there was, it was an event that came from the city. These pandemic rules would not allow it, and they wanted to come to the county. And they were in the process of providing the security plan to the police department. And the police department may have said that it was fine. But if they had to bring in additional officers on that site under this bill, although it's not a circus and not a carnival, that would be the kind of example where you would provide different additional detail pay. But I don't think that the rules are drafted yet because we were waiting until the legislation was prepared.
Madam Chair,
Sure.
I'm just going to comment with regard to Councilman Jones' question. And that is, you know, this legislation has been worked on for a long time, probably a few days or a week after the last incident at East Point Mall. So Councilman Jones, I mean, I agree with you that given the amount of time that this legislation has been worked on by the administration, we're now to a point where you're right, we should have some detail in this, which is what my amendment attempts to do. And, you know, and to your point, we don't know what the policies will be, and we don't know what the charges will be. That was something that came up on our meeting Friday afternoon with the event organizers and the administration. And we were told, well, we'll get the pay schedule to you when we have it. So again, you know, I just want to let you know I share your concern.
Madam Chair,
Yes, Mr. Malinow.
it's Izzy.
Oh, I'm sorry, Mr. Patoka. Sorry.
Just a question for Councilman Crandall and Mr. Boswick. In terms of the 10-year grandfathering, for lack of a better term, does that account for 2020 as being one of those years with so many events being canceled?
No, it does not. There's a force majeure line in there. So 10 years continuously operated
Up to the current year.
and without regard to COVID-related restrictions. Correct?
Thank you for that.
Prospect? I should have let you answer that. You would have been much more eloquent than I was.
That's right. It for the last 10 consecutive years leading up to the current year, excluding force majeure related cancellations, of which COVID would obviously be one.
Okay, thank you for that clarification.
Thank you, sir.
Madam Chair,
Councilman Catt.
yeah, I have a question for the administration. All these events that we're talking about, they normally have some police presence. So it is not your intention to bill for those hours. Is in the legislation in front of us, and I don't have it in front of me because I only have one computer operating. What is it in the bill that this pay situation only applies to police over and above what it would normally be provided?
Well, Madam Chair?
Yes, I'm sorry, Mr. Malinow. Go ahead.
Right. First of all, I want to make sure that I'm clear that we're talking about the regulations. We can't create the policy. That's what you all are doing. And it's the regulations under which they apply And what it says in the legislation is for carnivals and circuses that this would apply. And I don't want to read through, but it said that, it says on page 9, on line 9, shall include a security plan for the approval for the police department that includes details about security personnel to be supplied and so on. And then it goes to say that the participation in the police department detail pay program, if required, shall include a list of all similar events by the applicant. And it basically lists that the police department would only apply additional officers to an event, not the normal officers who would be in on duty at that time. I didn't articulate it very well, but that's how I understand the legislation.
Does that need clarification then in the bill itself? Because we really shouldn't be, the police that normally are part of these functions, that's expected. And does the legislation need to be more specific in regard to, we're only going to reimburse the police for additional police that normally wouldn't be involved in these carnivals, circuses, etc.
Madam Chair,
Yes,
I'm sorry, I didn't know who you called on.
yes, Councilman Crandall.
Sure. Councilman Katch, if I can just give you my 2 cents on that, on your question. I do not believe that it is this administration's intent to charge for police, charge our volunteer fire companies and rec councils and such, which is, that is not the intent of this bill. However, if you look at the language of the bill, it gives a future administration, or it does give that arbitrary authority to have to charge. Now, I will tell you, there are numerous events in my district where not only are these organizations working with the police well in advance of their event, many of them hire off-duty police as part of a off-duty police security company, or just they hire off-duty officers to secure their event. I mean, this happens, I think, quite often. The thing is, and I've mentioned this before, and we've had so many meetings on this, it all kind of blends together. But there is no malice intended in this, but the potential for this to really affect longstanding community events would exist if we pass this bill unamended.
Mr. Bostwick, would you or Adam, would you have any suggestions on, I know we're on Councilman Crandall's amendment, but any amendment that would tighten this bill so that future administrations would not be able to see this as another source of revenue?
Mr. Katch,
Yeah.
I'm sorry. Honestly, of course, it's not a council bill, it's the administration's bill. I think the amendments that have been considered and voted on by you up till now are good steps. I think that the administration has worked with Mr. Crandall and in general to improve the bill, and I think those do. But I also, again, it's not. I'm not an advocate here. I don't know. I'm not voting on this, but I don't really see how this amendment doesn't improve it as well. If you agree with the policy of exempting an organization that meets these 3 requirements, and you're exempting them from the detailed pay policy. That's all it's doing. So that, you know, maybe I'm just a simpleton, but I don't see it as rocking the boat tremendously.
Ms. Rogers, you had your hand up?
That's okay. It was responded to.
Okay. Anyone else?
Madam Chair.
Here, one more, if I could. I was just curious, notwithstanding any of the other issues in terms of constitutionality or not being able to tell whether or not somebody been around for a long time, notwithstanding any of those issues, is there any problem with grandfathering some organization that's been operating here in Baltimore County for 10 years without a problem? Notwithstanding any of those other issues, do you have a problem with grandfathering somebody who's been operating a good steward, doing the right thing for 10 years?
Can I make a comment? Does anybody care if I make a
No,
comment?
go right ahead.
And Mr. Crandall, you can correct me if I'm wrong, but I'm pretty familiar with most of these outfits. The ones that have been in business for over 10 years are the ones that are continuously the problem at those events. I won't call them out by name, but you know, one of them's been around since my kids were little. And every time they come to Point or to Colgate, there are always issues.
No.
Always.
So Madam Chair, if I understand your question, my amendment is trying to protect a future administration or protect our longstanding community events, and you know exactly which ones I'm talking about. These are nonprofits. These are the primary fundraisers throughout the year. So this would exempt. We have events that have been around longer than I've been alive, that have been continuous for over 50 years. So that is my intent, is to protect those longstanding community events that, by and large, are not issues for the police department. This is more about a traveling carnival that has been the source of a lot of resource drain for the police department and are a public safety issue.
Okay.
So that's the spirit of my amendment.
Madam Chair,
Yes.
this is James Benjamin. This is to answer Councilman Jones's point. Generally, I don't have concern with regard to grandfathering, but I think in this particular instance, we still may have, there still may be a risk of, I guess, application such that there could be a risk of discriminatory impact. So I guess that's where my concern is here. And I want to address a point raised by Mr. Boswick also. I appreciate what he's saying. I know he's been doing this for a very long time, but I've been doing this quite a while too. And it's my job to make sure that I raise concerns for people to think about with regard to legal issues. And that's what the charter tells me to do. And that's what I'm going to do. So I just want to make sure that that's clear. I'm not trying to step on anyone's toes or anything. I'm just trying to tell the law as I see it for the council's consideration. That's all I was trying to do here. So thanks.
Thank you, Ms. Rogers.
I'm just trying to think of this from the policy versus regulatory standpoint. Is it not the case that some of the fine-tuned details could be articulated in the regulations?
I guess it could, but we don't have the regulations in front of us.
But regulations typically are not promulgated until after the passage of the legislation, council member.
I'll let Councilman Crandall speak for himself.
Well, I'm not sure Ms. Rogers, if that is always the case. I guess certainly sometimes it is, but the overarching authority granted to the Baltimore County Chief of Police in this bill makes me very uncomfortable, because we don't know what criteria he or she, and whoever would be in that position, what criteria they would use. So we go back to my under certain circumstances phrase and my problem with that. So I appreciate what you're saying, but again, I go back to this like, well, let's just pass it and then we'll figure it out later. And I think that when it comes to these nonprofits in our communities that put these events on year after year, I would rather not expose them to that risk. That's the, again, the spirit of my amendment. So with that, I think we covered it. I'm going to go ahead and move the amendment, and hopefully I'll get a second and we can.
But I want to ask you a question first. With your amendments, though, if referring back to the Councilman Bevan's statement, if there is a group that year after year has had problems, they are not exempt from this regulation according to your amendments, correct?
I might have to defer to Mr. Bostwick on that. Wait, can you please mute, because I get a lot of feedback. I'm gonna say that if you look around Baltimore County and you look at the events, the fairs, festivals that would be considered carnivals, the ones that have been running for 20, 30, 50 years, they've had incidents. I think every single one of them. Somebody drinks too much, or there's a fight, or worse. So they're not without incident. But the ones that had so there's one in particular I'm thinking of in my district. They had 2 nights in a row where they had never had anything in the past 30 years, really, and they had an issue. They addressed it immediately and hired their own security. So I think that these longstanding events, they know how to deal with these issues. And again, I'll go back to my point where the event organizers are already working with police. They are building with the police department a de facto security plan. So this legislation codifies all of that, all these practices that are already being done. And I don't have issue with that, because I do know that the police are asking for a tool to help them regulate these events that these events get completely out of hand, where we have near riot situations that involve, one of them involved as I understand it, involved every single on duty that particular shift. Every cop in Baltimore County had to descend on this one location because it was so out of hand. And I think there were 27 arrests made. So did that cover your question?
Yes, and basically that group that had that carnival, whatever, would not be exempt from.
They would not. They would not. They have not operated for 10 years and with a nonprofit. Now, there's been a carnival at East Point Mall for a long time, since I was a kid, right, Kathy?
Before there, it was at Colgate Park on the other side.
Yeah, and there was nonprofit sponsorship of it in the past. But no, so, and in more recently, they've just leased the space from the owners of the mall or the manager of the mall. And I don't believe that they had any nonprofit sponsorship. But no, these sort of traveling circuses that have been a drain on resources, I want to support this bill to allow the police to have the legal authority to regulate these bad actors, as we've been calling them. I just don't want the people that are experienced in this and prove year after year they know what they're doing, to be lumped in with them.
Madam Chair, can
Okay.
I point out two areas of the legislation pertinent
Sure.
to our discussion?
Sure.
On page 3, there already is in Title IX authority for the administration to create regulations, not quite as defined. So the issue in the ability to set up regulations has been clear in the law for a long time. And then if you go to page 4, the amendment for purposes of the detail pay specifies in some that the chief of police may adopt a detail pay policy under this and under certain circumstances, and that detail pay may require prepayment. And then number 3, the administrative officer shall establish and from time to time review such fees. So the authority to set up the regulations is already there, and it just adds this element of it with a lot of review from the administration. So I don't see it as something new that we, except for the detail pay that we don't already have.
So Madam Chair, just to be clear, I think Councilman Catch asked that question. I'm not sure. But,
he did.
okay, so let's be clear that this amendment only pertains to the section of the authority of the chief of police to charge for on-duty detail pay. It does not do anything to the section that gives the authority for the administration to make regulations surrounding permitting. And those regulations, I mean, that authority, as Mr. Malinoff said, most of it has existed for decades. So should I just go ahead and move it?
Yeah, I think the discussion's over.
Okay, so I'll move the amendment.
I second it.
Okay. Mr. Secretary, please call the roll on the third amendment to Bill.
Yes, ma'am.
On Bill 10620. Yeah.
97-20.
97.
I forgot where we were. Holy cow.
Yes, ma'am. I'll call the roll. Mrs. Bevins,
No.
Mr. Crandall,
Aye.
Mr. Catch,
Aye.
Mr. Jones,
Aye.
Mr. Quirk,
No.
Mr. Marks,
Aye.
Mr. Patoka. Mr. Patoka?
Mr. Boswick, do you hear me now?
Yes, sir. Thank you.
So I am going to vote nay, but I want to explain my vote that I really appreciate the great work that Councilman Crandall has put in this and the great work that you've put in this, Mr. Boswick. But
Thank you, sir.
I have faith in Michael Malinoff that he will do the right thing in this. And so that's the reason for my vote.
Okay.
Madam Chair, if I can just respond to Mr. Patoka. I have faith in Mr. Malinoff as well, but Mr. Malinoff will not always be the director. So that's my concern, but you already voted, so thank you. And I appreciate the kind words.
Thank you.
Mr. Boswick, was that all members? You're muted.
I'm sorry, Madam Chair. That was all the members. If my count is right, I think it did pass 4-3.
Yes, it did. Okay.
Yes, ma'am.
Thank you.
So that is all the amendments, Madam Chair.
Phew. Okay. What did I say? Look, 1 hour and 15 minutes and 1. What did I say?
A very healthy discussion.
And
So,
Madam Chair, I would, yeah, am I on?
yes.
Yeah, I just would urge the administration, I'm pretty sure the bill's going to pass. If there are issues with what we've just done, please let us know, and I'm sure that, we can make any necessary changes to what we've done. Because we certainly don't want to put the county in the position of having to, having these events where there are problems. What you're trying to do is cut down on the problems or eliminate the problems. And I give you all the credit in the world. And if there's anything that we've done in this legislation that maybe won't work, please let us know. And I can assure you we will make any changes necessary.
Well, I guess before we move on, my question would have been how many of the members actually spoke to the police chief about this issue to see how they felt about the amendment. And that's where my vote lied. Okay, so now we're going to go back to 9720 as amended. Is there a motion to approve Bill 9720 as amended?
So moved.
Second.
Okay. Mr. Secretary?
Madam Chair, before we vote,
Yes. It was
I just want to thank our own team of counsel, of course, but also the counsel for the police department, the county law office, obviously Mr. Malinoff, Kimmy Routson. They were engaged. We had many discussions. They engaged community organizers. And I think that, I just appreciate everyone's effort on this. And I think this is kind of, to me, this was an experience that how legislation on the local level works when you're dealing with very complicated issues with definitions made up by someone that's not in Baltimore County, that was, drafted years and years ago. So I think it was a very collegial and productive process. And I just want to thank everybody for that.
Well, you're welcome, and thank you for the work that you put into it.
Thank you, Madam Chair. And also I want to thank our community folks who put in an extraordinary amount of time and thought into the bill as well.
Absolutely, absolutely. Okay, Mr. Secretary, so please call the roll as amended.
Yes, ma'am. Mrs. Bevins,
Aye.
Mr. Crandall,
Aye.
Mr. Quirk,
Aye.
Mr. Jones,
Aye.
Mr. Marks,
Aye.
Mr. Patoka,
Aye.
Mr. Catch.
Aye.
Bill 97-20 is passed as amended. Next item.
Yes, Madam Chair. If I can just find my place. Next is Bill 105-20. This is a bill sponsored by Councilman Jones, zoning regulations, parking.
Councilman Jones?
Yes, as discussed during the work session, this bill is just to lighten the parking requirement for a restaurant where I have a piece of property that is located in a, I forget the name of it, the type of zone where we are trying to encourage and my community is certainly want more restaurants, and restaurants right now are taking it on the chin. It's very difficult for every restaurant that's in business, let alone one that wants to start out. So I'm just trying to do my part here to help foster more economic development in the Liberty Road corridor.
Okay, are there any questions or comments for Councilman Jones?
No, Madam Chair,
Yes.
can I ask Mr. Benjamin, does he have any observations or comments on this bill?
I do not.
Okay, thank you.
Okay, Mr. Secretary, please call the roll on Bill 105-20.
Yes, Madam Chair. Mrs. Bevins,
Aye.
Mr. Jones,
Aye.
Mr. Quirk,
Aye.
Mr. Patoka,
Aye.
Mr. Catch,
Aye.
Mr. Jones, I'm sorry, Mr. Marks,
Aye.
Mr. Crandall.
Aye.
Bill 105-20 is passed. Mr. Secretary, next item, please.
Next, Madam Chair, is Bill 106-20. This is a bill sponsored by Councilman Marks entitled Zoning Regulations, Permitted Uses, BLR Zone.
Councilman Marks?
Yes, Madam Chair, I'd like to motion that this bill be laid over for the next legislative meeting, please.
Okay. Mr. Boswick?
I'll second that if you
Oh,
need
okay.
to.
All right. Mr. Boswick, please call the roll.
Yes, ma'am. Mrs. Bevins,
Aye.
Mr. Marks,
Aye.
Mr. Jones,
Aye.
Mr. Crandall.
We're voting on extending the life of 10620.
That's correct.
Yeah. Yes,
Okay.
sir. And I
Okay.
should have specified, it would be
I'm sorry.
extended. It would be extended to the next meeting, which is December the 7th, work session, December 1.
Okay. Aye.
Aye.
Mr. Capps,
Aye.
Mr. Patoka,
Aye.
Mr. Quirk.
Okay, the extension is passed.
Thank you, Madam Chair.
Mr. Secretary, next item, please.
Next is Bill 107-20. This is also sponsored by Councilman Marks, entitled Zoning Regulations, Bulk Regulations, Residence Apartment Elevator RAE2 Zone.
Mr. Marks?
Thank you. Thank you very much. I'm going to have two questions at the end for Mr. Boswick and Mr. Benjamin, but let me just make some comments. Last Tuesday, you heard from a broad coalition of neighborhood and environmental representatives who testified in favor of this legislation. I would also like to thank Senator Chris West and Delegate Kathy Forbes for their impassioned testimony in addition to those who spoke on Tuesday. As council members, our job is to represent the constituents who send us to Towson, and that is what I try to do. I'm fully aware of the legal agreement signed by our former county executive 4 years ago. When Red Maple Place was proposed, I tried to work with the developer to modify the location and scale of this project. In fact, at my request, this council passed legislation that allowed for the building to be shifted to the west. So this council has a history of working to accommodate and not kill this project. The location was modified, the size was not. The developers claimed that scaling back the project would compromise its funding. But why then did the developer not appropriately engage the neighborhood before obtaining a commitment of this funding? They've also been threatened with a lawsuit. Developers threaten lawsuits all the time across this country when they don't get their way. Unfortunately, what we've heard from some advocates for this project is a my way or the highway approach. The project must go here at this height at any cost. I've served on this council for 10 years, and I voted for a lot of bills that are only in one council member's district. I'm concerned that if we kill this bill, it will send a chilling message that threats from outside interests matter more than listening to the residents most affected by development projects. The members of this council are honorable men and women. I've never disparaged your integrity, and it is my pleasure to serve with all of you. And I'm sorry you've been placed in this position. I'm also sorry that the developer could not respect the wishes of the residents who will be most affected by this project. And with that, Madam Chair, I just want to have two questions. First, to Mr. Bostwick. Mr. Bostwick, can you describe what Bill 5419 did? And that was a bill that we passed earlier this year, Bill 5419.
Bill 5419 also was a bill that modified a height requirement in the zone that it applied to under certain circumstances. And there were some location requirements. There were some school overcrowding requirements for that height requirement to kick in.
Thank you. And my understanding is that that bill passed, I believe, unanimously. So thank you, Mr. Bostwick. And then finally, and then I'll be quiet. I want to ask Mr. Benjamin a question. Mr. Benjamin, did your office issue an opinion on this bill? Do you remember?
With regard to 5419, I know that at the time that bill was considered, I was not county attorney.
Okay.
I did not come in until November. In fact, today's the 16th. My 1 year anniversary is in 2 days.
Okay. And that's why it was your office. So the office, the office of the county attorney. Okay. Are you aware if there is a lawsuit as a result of that bill?
With regard to 5419,
Yes.
I am not aware of a lawsuit with regard to that particular bill, but I am aware that the fair housing advocates have identified, based upon correspondence to me, 3 separate instances where the county, through facially neutral legislation, have the legislation was such that it prevented affordable housing from being built. And that would be sufficient at the very least to demonstrate disparate impact. But as I sit here, I am not aware of a lawsuit being specifically filed as with regard to 5419.
Okay. Thank you. That's all I have.
Are there any questions or comments for Councilman Marks?
Madam Chair, I have a question.
Yes.
Yeah, I drove to the site a couple days ago, and I do agree with the people who have environmental concerns regarding that piece of property. I think that it's very regrettable that it's gotten to this point. But I wanted to ask Councilman Marks, was this an issue during the CZMP process that or not?
Yeah, there's one, and I debated it, quite frankly. And the prospect of a lawsuit came up then as well. I thought passing a bill that was more applied throughout the entire community was the way to do this. And I'm going to be honest with you, Councilman Katz, I had discussions with representatives from the developer. They said to me, if you don't downzone this, we will work with you. We will try to modify the size. Maybe we'll be able to replace the money that was going to be lost from the state. And we'll work with you, Councilman Marks. And lo and behold, the project kept moving through the pipeline. So that is why I did not downzone it. There's 2 reasons primarily. Another council member downzoned a project in his district, and that was his prerogative. I thought that this was the better route to go. And quite frankly, I thought the developer would work with the community to modify the project, which has not happened.
So it did not happen?
Did not happen. I had those discussions. The issue was funding. The developer, I think, has mentioned the issue of funding. And I had hoped that we could come to a better arrangement.
Okay, so Councilman Marks,
Mhm.
I'd like to say a few things. First and foremost, I respect you, and I think 99% of the time, respected councilman out of courtesy for my fellow council members, and I would always hope that I would have the same respect. I am not against these type of housing projects. I have my fair share in my district, and they are, working families, paying taxes, part of our workforce. Children have an opportunity to go to better schools when these types of projects happen, for sure. And I also like to respect what communities want. And I heard from the folks in the community at the work session, and they were very passionate. With that being said, I'm just a little confused about maybe what we're asking for. So I know that what's on the table here is the building is too tall. So I'm guessing we can go back to, I want to say, and forgive me for looking down, but I wrote the dates down so I wouldn't mess them up. So in March, you asked Homes for America to move the building on the property line further away from the folks at Harris Hills, correct?
That's the legislation I referenced.
Right. So in order to do that without triggering the zoning variances, you introduced Bill 8-20 and to adjust those setbacks. So you asked the council at that time to support you, and we all did. 100%. We supported you on that legislation. So after that legislation was voted on March 2nd, I guess Homes for America probably spent $300,000 to $400,000 at least or to re-engineer that site, I would guess, okay, because they started over on where it was going to be placed because of the legislation. So to me, because I'm not about slow nose, so for me, that is moving that project forward. One more step. We voted to let that happen. They made the investment. Then again in August, the Harris Hills Condominium Association did ask for you to downzone the property, and you didn't downzone it, right? So you asked this council again as a whole to support your CZMP issues, which we did, and happy to do so. So that's 2 times we support, the council as a whole supported you on this issue. Now, 4 months later, you're asking us to go against both of the votes that we already voted on, essentially, correct?
The first vote, which I mentioned in my comments, was about the location. I have had concerns about the location and the height of this project. The developer, to their credit, worked with us on the location, not the height.
Now, from what I understand, they said from the very beginning they could never take any units off. Is that correct?
They didn't, the conversations in August were that they would work with me to pursue funding to replace that funding that might be lost if the height went down. That was, and I also want to say it was also a representative for the property owner as well.
So I don't know, for me, you know, this isn't the first time I've ever said this. For me, I'm always about no slow nose, and I try to stop businesses from spending any amount of significant money, you know, with knowing that the project's not going to move forward. Now you're saying in all fairness that you did try to work with them. So I'm trying to be sympathetic to your residents that live there, but I also know that us as a council, all 7 of us voted twice, basically to support this project because it could have been downzoned. And we went against the community then, you went against the community then and didn't downzone it. And now you're asking us to not let this happen. So I'm really confused on what I'm supposed to be doing here as a council member with it not being my district. Because you're their representative, they're your constituents, but I'm still really confused on the votes that have taken place over the last year.
I do want to clarify, because you said I went against my community. I'm also a county council member, and I'm very cognizant of the agreement that the former county executive entered into in 2016. And I have never said I am against getting affordable housing at this site. I'm against the scale of the project. So I have tried to act in a moderate, conciliatory manner, given the fact that all eyes are on this county. That's why I worked with the developer earlier this year on the location, and that's why I thought taking this route was better than downzoning.
Right, and that too, I mean, I was very vocal on the Home Act, you know, so making sure that this project happens. I'm also a little confused about Homes for America because all the projects that I'm familiar with that they've done, after 15 years, you go from rental into home ownership. And I think that that's a great program. You know, you teach people about saving money, budgeting, keeping their credit great, maintenance, all those things. But your project is not going from rental to home ownership. It is all rental. But I heard from your community, and a lot of them just said it was the height. So I'm really confused on this whole issue, quite frankly. Would anybody else like to speak on this? Ask any questions?
Yeah.
Yes.
I guess I had a question. I've been diving deep into this development and into this project just because of all the attention it's been getting. And I'd like Councilman Marks to explain to me about height again, because I too went out there and took a look at it, and right now I'm just refreshing my mind looking at Google Earth. I have a 17-story building a half a block away, and then in the same block is another story office building on the corner that's 5 stories. And 405, which is right beside this building, is 4-story office building. So what is the story with the height? There's the demarcation line, and it's sitting on Joppa Road. So every property I see there looks like it's commercial of some type, maybe an office, maybe it used to be a home, but now it's an office. So can you please explain to me where the demarcation is and what is the issue with the height of the building?
There's a clear demarcation between downtown Towson and the neighborhoods that surround downtown Towson. This is not downtown Towson. I mean, Fairmount Avenue is generally considered the demarcation with downtown Towson. And that's why the bill applies to all RA zone property. And I mentioned in the work session, if you look at other apartment buildings in Rogers Forge and Knollwood, they're generally a 3-story height. That's why I went with that 3-story height. And if you ask the Harris Hill community, which surrounds the community, they would tell you it's a pretty high building.
Okay, thank you. I thank you, Mr. Marks. I understand now. I guess the next question I have with, just to refresh my mind, Mr. Benjamin, what are your concerns, Mr. Benjamin?
Councilman Jones, there are a couple of concerns I have. One, I'm concerned that the county has not fulfilled its obligations under the VCA. At least that's what the fair housing advocates have alleged. And I'm concerned that if it's determined that this has prevented, this bill has prevented another affordable housing development, we could have a situation where HUD and the fair housing advocates could bring an action for contempt in federal court for noncompliance with the VCA, and also the issue that I talked about earlier regarding the fair housing claim and establishing a prima facie case for a disparate impact. And my concern is also economic as well. If a court were to determine that the county had violated the Fair Housing Act, we could be liable for compensatory, consequential, and punitive damages, as well as attorney's fees. And so that could cost the Baltimore County taxpayers millions of dollars. And even if the county were ultimately to prevail in court, you're still talking about costs for defending the lawsuits. And this would involve, of course, significant resources as well. So, which would require outside counsel most likely. So again, it's my job to be able to share my concerns with things I'm seeing and advise the council on that. So both concerns with regard to VCA, fair housing, and ultimately how this would impact the county from an economic standpoint.
Okay, Madam Chair.
Yes, Councilman Crandall, and then I thank Councilman Quirk.
Okay, thank you. So, Mr. Benjamin, how many units are we behind with where we should be according to the VCA?
1,500.
Well, it's my understanding that by the end of calendar year 2020, the county is required to have 570 units approved. And it's my understanding that at this juncture, the county is about 67 units short of the requirement, even if you were to include the Red Maple Place development.
Okay, so what is the contention, what is the legal argument that is being made? We're not going to reach the goal anyway. Then why would this particular project that would not meet the goal or not help us meet the goal, why wouldn't they sue the advocates sue Baltimore County or the Fed sue Baltimore County anyway?
Well, that very well could be the case with regard to, I'm talking about with regard to the VCA. Or you're talking about the voluntary compliance agreement. We are behind, but if this bill, with regard to this bill, you're still talking about possibly 117 units being the kind that would be behind. But my bigger concern is this whole issue of the fair housing claim that they could bring. And as I said before at the work session, a party to be successful on a fair housing claim must establish either intentional discrimination or show that facially neutral legislation such as Bill 107-20 would have a disparate impact on a protected group of persons. So as I said to Councilman Mark's question, they've identified 3 separate instances that their fair housing advocates have, where the county through facially neutral legislation have prevented affordable housing from being built. And so that could be used to establish this disparate impact. And it could also be established or used to establish a pattern of practice of utilizing legislation to prevent the creation of affordable housing units in an opportunity area. So it's my job as counsel for Baltimore County, for the council, for the administration to advise of this and to make sure that people are aware that this could end up being a prima facie claim with regard to fair housing that could end up involving protracted litigation, protracted discovery, and again, could significantly impact the taxpayers. Sir.
Councilman Quirk. And then,
Thank you. Thank you, Mr. Benjamin.
Councilman Quirk.
Thank you, Madam Chair. Just to follow up on your comments, Madam Chair. In addition to the council supporting Councilman Marks with CZMP and everything you mentioned with the resolution 111-20.
Oh, I forgot about that.
Supported Councilman Marks putting this basically project in design review panel, which cost the developer $300,000 to $400,000 more that they had to spend. So it's something we also supported Councilman Marks because this is in his district, but it's something that it feels like the goalpost keeps getting changed on this project.
Councilman Quirk, Council Chair, can I ask Councilman Quirk a question?
Sure.
Councilman Quirk, where did you get that number, $300,000 to $400,000?
That's the number I was told. Yeah.
So let me explain what happened with the design review panel. You know, all of us are dealing with development hearings that take months to happen. We passed that bill, that resolution, and all of a sudden, the design review panel hears this project. I find it really hard to believe that it cost $300,000 to $400,000 for a hearing that was held last Tuesday when we passed this resolution at, last meeting. I mean, I'm not questioning you, Councilman Quirk. I'm questioning whoever told you that number. It seems like an awfully high number.
Okay. Ms. Rogers? I'm sorry, Councilman Quirk, were you through?
Yeah, I think it was to move the building. I think under the first legislation, I think was the drawings and the architecture and everything else to kind of try to accommodate one of your first concerns about where the building location was. So I think a lot of the money was spent after that, I believe.
Okay, Ms. Rogers?
Madam Chair, Attorney Benjamin stated in his statement what I was going to say with
Okay.
respect to the fair housing advocates.
Right. And is there amendment to this bill?
There is, Madam Chair. I believe Mr. Marks is offering an amendment, and the amendment would indicate that no variance to the height requirement in the bill, it would not be eligible for a variance.
Can I explain the amendment?
Madam Chair, I have one more question for Councilman Marks.
Yes.
I was just thinking about the Fairmount Avenue demarcation line. So where does the public safety building for Baltimore County, which is, I don't know how many stories, 13, 15 stories, where does that sit?
That's outside of the demarcation line. You know how old that building is, Councilman Jones?
I know it's old enough for the windows to be falling out a couple of years ago.
I ask that because look around Towson. We have 14, 15-story buildings that just got out of nowhere because we had poor planning in the 1970s, 60s, and 70s. And we have tried to make an effort to be better planners in Towson, and I'd like to think that this legislation is part of that.
Thank you.
Madam Chair.
And it used to be the Blue Cross Blue Shield building. So,
Madam Chair.
Yes, Councilman Matoka.
Thank you. So I'm very conflicted on this. Councilman Marks, I have a great deal of respect for you. I know that you are deeply concerned about your district and doing right by your district. I've received numerous letters from constituents that are supportive of your bill. And I've received a few from the other side, but most folks seem to be very supportive of this. Where I'm conflicted is that we have defined, I think intentionally, we've defined Towson as our most urbanized part of the county, where we have a circulator coming in. We have those things that are typical of an urban environment and the fabric of neo-urbanism and not just neo-urbanism, but that kind of environment in Towson, and you know we're introducing transit to Towson. Imagine that with the circulator. And so on the one side, I feel that I want to support you as much as I possibly can, because I feel that you know your district better than I do. And I believe that to be true with all of our colleagues, that we each know our districts better than the other 6 members. And that's why we were each elected for our districts. So I'm trying to right size myself in terms of constituents that are your constituents and constituents outside of your district that support this legislation. But to some degree, I feel like the horse is out of the barn in terms of urbanizing Towson. I do think we need to move towards compliance or meeting our voluntary compliance agreement. And so I'm waiting to hear, I guess, in the discussion and dialogue we're having right now, what the compelling argument that's going to push me one way or the other.
Here's the compelling argument, Councilman Patoka. We could still advance toward meeting our goals in the affordable housing settlement with a smaller building. And there is nothing wrong with asking a developer to modify a project instead of that building being standing for 60 or 70 years. This is the point where we should act on behalf of people who have asked for our help. It's an inconvenience for a developer, and yes, they have to go back and modify that building, but it is better than that structure standing for decades. We build the structure in a manner that is friendlier to the community, and we still advance toward the goals of the Affordable Housing Agreement. That's the argument I would make.
What's the difference in units, Mr. Benjamin or David, Councilman Marks, in terms of where we would be with the height restriction and where we would be without the height restriction, or with the existing height in place?
I would think it would drop the units to maybe in the 40s.
40 fewer units, or
In the 40s. It would go from the 60s to the 40s.
for Mr. Benjamin,
Oh, sorry, yeah.
what does, and then Councilman Crandall alluded to this earlier, that we're not going to meet what we've agreed to. Having 40, I think the number you said was 67, that we were 67 off of what we had agreed to. And with this additional 40, that would put us 107 below what we were hoping to be at.
Well, my concern is that you're looking at a pattern, and you're looking at a situation where you may have evidence that would demonstrate a disparate impact, in part because we haven't been able to achieve compliance with the VCA. And I'm concerned also too about this potentially being a chilling effect with regard to developers being able to come in and build affordable housing. I'm concerned again about the fair housing component, that as far as them looking at trying to establish the county engaging in a pattern or practice of utilizing legislation to prevent creation of affordable housing. So it's different factors that have led me to the views that I have and the concerns that I have. And then also too, keep in mind, at least with regard to the VCA, if it's determined that we are not in compliance, we could be ordered to perform a specific actions to build its own affordable housing, and we wouldn't necessarily have the funding to support this endeavor. So even though right now we are behind, I think that looking at the totality of with regard to the VCA, as far as the compliance, as far as meeting the benchmarks I'm talking about, when you look at the totality of the circumstances, it's concerning that not only are we, according to the advocates, not in compliance, but it could lead to, again, allegations of fair housing discrimination, disparate impact that could end up leaving the county in protracted litigation for a long time.
Are there any graphs that show our progress towards our compliance? How are we doing? What are our goals? How are we going to get there?
Madam Chair, I can respond to that. Councilmember Patoka, yes, we have a benchmarking for each of the provisions of the VCA. When I came to the county, this was one of the first issues that I was presented with respect to where we are. This is an interim goal in terms of the amount of units that we should be at by this point. So of course, we have been trying to catch up, but we absolutely have the data on what projects we have applied toward it, what projects had units that were going to be applied toward the goal, like these units were applied toward the goal. We have a myriad, they have like over 13 different provisions of the VCA that we track and monitor and meet on a monthly basis. And we meet quarterly with the advocates. It just so happened that at the point we had our last quarterly meeting, the advocates and the representatives from HUD expressed their concern. But we have the data and the—
Is it possible to share that with council? I would ask Madam Chair if that would be acceptable to her.
Oh, to share it?
Yeah.
Sure. You mean now?
Not now, but as
I'm sure.
Absolutely. It's something that we are tracking very closely and really had worked very, very closely with the advocates and HUD. As a matter of fact, HUD's faith in us over the last year, the steps that we've taken increased to the degree that they awarded us additional technical assistance to work on a strategic plan with the enterprise subcomponent of the Enterprise Foundation in a time when very little money was being awarded, additional money was being awarded for technical assistance, but we did receive that funding.
And I think it's really important for council to see the metrics on that, because we do hear that we need to do A, B, or C because of the VCA, but we don't, at least I don't have a clear picture of where we are right now on the VCA. I mean, we've had some discussions, but I would almost like to have a chart in my office when I return to my office at some point, hopefully in the future, that we know where we are, and it's especially important to us because we have such a strong responsibility for land use, and I think it's important that we do see that, and I think it's something we should work towards. But having those metrics would be extremely helpful.
Absolutely.
Okay. Thank you, Ms. Rogers. Mr. Marks, is it true that the Homes for America have stated that they will lose their credits? That's why they can't take any units off, that they can't, they just can't give you any units because they'll lose their credits, and that'll squash the project completely?
The loss of funding has been raised by them, which is why when I was discussing downzoning, I suggested that they talk to the administration about possibly getting additional funding. And the representatives for that developer said they'd be happy to have that discussion.
Okay. All righty. Mr. Boswick, can you tell me the amendment again? Because I've forgotten it and it's time to move it.
Yes, ma'am. The amendment, so the bill, as we know, would state that multifamily buildings located within 500 feet of the downtown Towson district would have a maximum height of 30 feet. And the amendment that I believe Mr. Marks will offer would also indicate, as part of that no variant maximum height requirement may be granted under the provisions of the zoning regulations.
Well, the review panel already voted on the 45 feet, so does that matter one way or the other now?
Well, if you're talking about the design review panel, they can do that. That's part of what they do, but that would not affect, but if this bill passed, the height would then be, the maximum height would still be what it is in the bill, which is 30 feet. And the amendment, and I think that would control, and the amendment would state that no variance from that height may be granted as well.
Okay. If there are no further questions for Mr. Benjamin or Councilman Marks, is there a motion to move the amendment?
So moved.
Is there a second?
I'll second the amendment.
Okay. Mr. Secretary, please call the roll on the amendment to 107.
Madam Chair, is it too late for clarification in the process?
Nope, I don't think so. Is it?
So just Mr. Boswick, effectively, what does this do to the actual bill?
So the generally, I guess maybe let me back up, and I should have clarified this maybe a little better when Madam Chair asked. Generally, there are things in the zoning regulations all over the place regarding height and area setbacks, requirements, maximums, and generally speaking, even with these requirements, there is a provision in the zoning regulations in section 307 that allows for a variance to be requested and potentially granted by the administrative law judge, after a public hearing. In other words, if there was a 50-foot height maximum and someone wanted to have a 70-foot height, they could theoretically go to the Office of Administrative Hearings and request a variance from that 50-foot max to in lieu of 70 feet. And the ALJ would consider all the factors that are relevant to the fact pattern and apply the law. And there's a case right on point with regard to variances called Cromwell versus Ward, which is the seminal case in Maryland that deals with the granting of variances. And again, variances are usually requested for area or height restrictions in the zoning regulations. So, and so what Bill 10720 does, as you know, is it sets forth a maximum height of 30 feet within the downtown Towson district. And Mr. Marks, I believe with his amendment, is also stating that specifically that no variance to that height requirement may be granted. So he is issuing a policy that even though there are areas of the zoning regulations that allow for height and area variances, in this particular situation, there would be no variance to that requirement.
Madam Chair,
Yes, Councilman.
this is James Benjamin.
Oh, I'm sorry. Go, Mr. Benjamin.
Just to make sure that the council members have context, the reason why this is important, this is relevant, is because their hearing, is my understanding, is scheduled for Thursday, the 19th, with regard from the developer concerning variance. So that's the reason why that this becomes relevant.
Madam Chair, may I ask Mr. Benjamin something?
Yes, sure, Councilman.
And I'll also ask Mr. Boswick for his opinion, since we have two very good legal minds advising us. Mr. Benjamin, my understanding is that the attorney for the project filed that variance request anticipating this bill passing. Have you ever seen anything like that before? A variance being proposed for a bill that hasn't even passed?
I have not.
You've never seen that before. Okay, and then the second question, and I'm going to ask Mr. Boswick the same thing. Are you aware if the attorney met the 30-day requirement between the time of the application for the variance and the hearing date? Do you know if that was honored?
I think what you are alluding to, Mr. Marks, is the section in that requires 30-day. That requires that, in addition to the notice provisions, such as posting and publishing, that a hearing may not be scheduled within 30 days and not more than 120 days after a petition is accepted for filing. And it's my understanding that this petition was accepted on October 29th. And as Mr. Benjamin indicated, there's a hearing, I think, scheduled for the 18th or 19th, I forget exact. And so I think if you just do the math, it would not.
So Mr. Boswick, in your opinion, that hearing is not meeting that requirement, correct?
Well, opinion, it's clear that when you add the days, it's less than 30.
Okay, that's all I have. Thank you. Thank you both. And Mr. Benjamin, thank you for your testimony. So thank you for what you provided us.
Thank you.
Well, I appreciate it. You're very welcome. And just to say that my analysis with regard to the fair housing and the VCA stands.
I respect your insights. Thank you.
Thank you.
Where were we? Okay, so do we have a motion for the amendment?
I did that.
And Todd was the second?
Yes, ma'am.
Okay, Mr. Secretary, please call the roll on the amendment to 10720.
Yes, ma'am. Mrs. Bevins?
Abstain.
Mr. Marks?
Aye.
Mr. Crandall?
Aye.
Mr. Jones?
Nay.
Mr. Patoka?
Aye.
Mr. Quirk?
No.
Mr. Katch?
No.
Madam Chair, I think it's 3-3 and a tie. So I think the motion, I think the amendment fails.
Okay. All right, so the amendment fails, and now we can vote on 107-20 not amended, correct?
Yes, ma'am.
Okay, is there a motion?
So moved.
Is there a second?
I'll second.
Mr. Boswick, please call the roll.
Yes, Madam Chair. Mrs. Bevins,
Abstain.
Mr. Marks,
Aye.
Mr. Crandall,
Aye.
Mr. Quirk,
Abstain.
Mr. Patoka,
Aye.
Mr. Katz, Mr. Katz.
Yeah, I heard.
Oh, I'm sorry.
No.
Mr. Jones,
Abstain.
So is that 4? So the bill fails?
3 votes in favor of the bill, 3 abstain, and 1 against.
So the bill fails? I'm not sure. I think so.
We've never had this situation, Madam Chair. I don't know whether 3 constitutes a majority or not in this situation. I'd have to actually look into this, unless Ms. Belcastro has some better institutional knowledge than I do.
Well, Mr. Boswick, I've been here a little longer than you, and I don't ever remember this happening either.
So are you saying abstains are not counted as the no? You're certainly,
Correct.
yes, they're certainly not a yes, right?
I
Right.
thought the only thing mattered was the yes votes.
Correct.
And there were 3, right?
Yes, ma'am.
So it didn't pass.
Patty? Are you banging the door?
Who's talking?
I think, let me, I think I got it. No bill shall become, this is section 308 D of the county charter. No bill shall become law, nor any action requiring approval of the county council become effective unless it is passed or approved by the affirmative vote of a majority of the total number of county council members established by this charter, or such greater number as may elsewhere be required. And on final passage of a bill, the vote of each member of the council shall be recorded in the journal. So based on that, and Mr. Benjamin, correct me if I'm wrong, based on that, I believe the bill fails.
Okay, so
I believe that's correct.
Bill 107-20 has failed.
Yes, ma'am.
Kind of like having the popular vote, but not the electoral college.
Very similar. The council will now consider all fiscal matters. Extensive testimony was taken at the council's work session on November 10th, 2020. The witnesses who testified at the work session are available to reinstate their testimony if needed. If a council member has any questions regarding a particular fiscal matter, that item will be discussed as a separate matter. I will now call upon the secretary to read the cover letter for fiscal matters 1 and 2.
Thank you, Madam Chair. Fiscal matter 1 is a budget appropriation transfer number 21-01 with the Department of Aging. Fiscal matter number 2 is a contract with Class Action Administration LLC, doing business as JND Legal Administration. This is for claims administration services through the Office of Law.
Thank you. Are there any questions? Okay, hearing none. Is there a motion to approve fiscal matters 1 and 2? I'll move it. Is there a second?
Second.
Okay. Mr. Secretary, please call the roll on fiscal matters 1 and 2.
Mrs. Bevins,
Aye.
Mr. Jones,
Aye.
Mr. Catch,
Aye.
Mr. Patoka,
Aye.
Mr. Marks,
Aye.
Mr. Quirk,
Aye.
Mr. Crandall.
Aye.
Physical matters 1 and 2 are approved. We will now consider miscellaneous business. Mr. Secretary, first item.
Madam Chair, whenever a contract over $1,000 is awarded by process other than formal competitive bid, it is required that a copy of the contract be given to the county council and the nature and parties to that contract be announced by the secretary at the next legislative session following award. There are 11 such contracts on the agenda this evening, and I'll just go through them very quickly. The first is with Premier Staffing Source Incorporated for temp nurses at COVID test sites, $164,233.70. The second is contract with Nolt Produce Supplies for agricultural produce during COVID-19, $32,085.20. Next is S&S Planning and Design LLC as part of the county's hazard mitigation plan update, $46,850. Armed Security Incorporated doing business as Butler Security. This is a contract for unarmed guards at ballot boxes during COVID-19, $164,660. The fifth contract is with Safeware Incorporated for gloves, powder-free gloves, $451,110. Next is Brody Transportation Company Incorporated for trailer rentals during COVID-19, $29,352.75. The seventh is with Realtox Labs LLC for COVID-19 testing services, $280,000. Next is RMI Designs Incorporated for sneeze guard, plexiglass sneeze guards during COVID-19, $69,125. The ninth one is with Edward G. Rall and Sons Incorporated for box produce distribution during COVID-19, $1,100,000. And next is with ARV Enterprises Incorporated for trailer and RV rental during COVID-19 at testing sites. This is an existing purchase order, and the additional total amount is $4,900. And finally, Crime Point Incorporated, cameras and HD modular low light NVR. This is for the police lab, $42,620.16. And that is all, Madam Chair. Thank you.
Okay, thank you. Next item, please.
Next is 129-20. This is a resolution to approve the extension of the sanitary sewer system in the Milford Mill area.
Okay, we have Ms. Deandra Walker. Are you with us? Are you still?
I am.
How are you this evening?
Good, Madam Chair. How are you?
I'm fine, thank you.
Well, good afternoon, Madam Chair and council members. The administration is requesting your approval of the resolution for Cliff Mar Road Sewer Extension, which is a health project. And because of the nature of this project, there are certain requirements and benefits to the property owners. In accordance with Articles 20-2101 and 20-2102 and 20-2105 of the Baltimore County Code 2018 and the departmental policy, property owners must connect their property to a public sewer system and abandon the septic system. Connection to the sewer system must be within 1 year of the notice of completion and release of the system. The notice of completion and requirement to connect will be sent to property owners when the system is complete and available for service. The annual sewer benefit and construction loan charges will be added to the property tax bill issued July 1st following the notice of completion. Benefit assessments and construction loan charges are liens on the property. However, the county treats them as assumable liens. The county does not require that these charges be paid off to sell or transfer the property to a new owner, except in certain situations involving property subdivisions and commercial properties. And then the construction, this affects 23 improved properties in the Cliffmore area. And the construction cost is $857,000, of which the property owners will pay $485,000. And then Baltimore County will be responsible for $372,000, of which $294,000 is the county assistance requiring county council approval.
Thank you. Are there any questions or comments for Ms. Walker? All right, is there a
Yes,
motion?
Madam Chair,
Yes.
I had one question for Ms. Walker. I was just curious. So far, has there been any objections of any of the constituents in that area that are affected?
Not to my knowledge, sir.
Okay, thank you.
Is that all? Okay. Any other questions?
Can I ask a question, Ms. Walker?
Mhm.
In which council district is this located?
This is in, I can tell you, just one second. I have it right here. It's 2.
Is it in 2 or 4?
2 and 4. It's a portion in 2 and a portion in 4 is what my note said.
Okay, thank you, Ms. Walker.
Mm-hmm.
Okay, is there a motion to approve resolution 120-20?
Aye.
So
I'll motion.
Second.
Okay. Mr. Secretary, please call the roll on resolution 120-20.
Mrs. Bevins?
Aye.
Mr. Patoka?
Aye.
Mr. Jones?
Aye.
Mr. Crandall?
Aye.
Mr. Marks?
Aye.
Mr. Quirk?
Aye.
Mr. Catch?
Aye.
Is that everybody? Resolution 120-20 is passed. Mr. Secretary, next item, please.
Yes, Madam Chair. Next is Resolution 130-20. This is a resolution sponsored by Madam Chair to authorize the property tax refund to Mr. Clifford Hudson, who as a disabled veteran is entitled to a refund under state law.
It's my absolute honor to move this resolution.
Second.
Ms. Secretary, please call the roll on resolution 130-20.
Mrs. Bevins?
Aye.
Mr. Quirk?
Aye.
Mr. Patoka?
Aye.
Mr. Catch?
Aye.
Mr. Jones?
Aye.
Mr. Marks?
Aye.
Mr. Crandall?
Resolution 130-20 is passed. Mr. Secretary, next item, please.
Next is Resolution 131-20. This is a resolution sponsored by Councilman Jones to authorize the property tax refund to Mr. Darrell Jones, who as a no relation, who as a disabled veteran is entitled to a refund under state law.
I'll move the resolution.
Second.
Okay, Mr. Secretary, please call the roll on resolution 131-20.
Mrs. Bevins?
Aye.
Mr. Jones?
Aye.
Marks?
Aye.
Patoka?
Aye.
Mr. Crandall?
Aye.
Mr. Quirk?
Aye.
Mr. Catch?
Aye.
Resolution 131-20 is passed. Next item, please.
Next is Resolution 132-20. This is a resolution sponsored by Councilman Quirk to authorize the property tax refund to Miss Angela Schnivink, who as a disabled veteran is entitled to a refund under state law.
My honor to move it.
Second. Mr. Secretary, please call the roll on resolution 132-20.
Yes, ma'am. Mrs. Bevins?
Aye.
Mr. Quirk?
Aye.
Mr. Crandall?
Aye.
Mr. Marks?
Aye.
Mr. Jones?
Aye.
Mr. Catch?
Aye.
Mr. Patoka?
Aye.
Resolution 133-20 is passed. Mr. Secretary, next item, please.
I'm sorry, I had misspoke, Madam Chair. It was 132-20.
Oh, I'm sorry.
Um,
I'm sorry. I
That
scrolled
was my
too
fault.
quickly. I scrolled too quickly. 132-20 is passed. Next item.
Thank you. Next is Resolution 133-20. This is a resolution sponsored by Councilman Jones to authorize the property tax refund to Mr. Carlos Latney, who as a disabled veteran is entitled to a refund under state law.
It's my honor and privilege to move the resolution.
I'll second. Mr. Secretary, please call the roll on 133-20.
Mrs. Bevins?
Aye.
Mr. Jones?
Aye.
Mr. Quirk?
Aye.
Mr. Patoka?
Aye.
Mr. Catch?
Aye.
Mr. Marks?
Aye.
Mr. Crandall?
Resolution 133-20 is passed. Next item, please.
Next, Madam Chair, is Resolution 134-20. This is a resolution for approval of the Baltimore County Financial Assurance Plan under the Watershed Protection and Restoration Program for introduction only this evening.
Thank you. Next item.
Next is Resolution 135-20. This is a resolution that would approve the continuation of the state of emergency pursuant to the initial executive order number 2020-002, also for introduction only this evening, ma'am.
Thank you. Mr. Secretary, is there any further business to come before the council?
There's no further business, Madam Chair.
Is there a motion to adjourn the meeting?
So moved.
So move. Second.
Second.
Okay, all in favor?
Aye.
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 This meeting, that was a sure sign. This meeting is adjourned.
Good night, everyone.
Thank you. Good night.
Thank you, Madam Chair.
Good night.
Have a good
Everyone
evening.
stay safe.
Thank you.